Judiciary Committee this Thursday morning, January 29th, and we're back to H578, the Animal Cruelty Bill, and we have draft number 1.1 to take a look at. And over to you, Legislative Counsel Eric. Thank you for being here, and thank you, Hillary, for backing him up.
Thank you very much to everybody. Nice to see everyone this morning. Eric Fitzpatrick with the Office of Legislative Counsel. As the chair said, here to walk the committee through a proposed strikeout amendment to H578, enacting penalties and procedures for animal cruelty offenses. So this is a strikeout amendment, and if you've seen a hard copy of it, you can see it's pretty lengthy. There's a lot to it. There's a lot of new language. There's some language that's struck. I, as have done in the past, have used yellow highlighting to indicate where the changes are between this draft and the previous one. I will refer to some of the unchanged, unhighlighted language a little bit as I'm going through it, because it's sort of helpful to understand what it was, to understand what the proposal is in the amendment. But for the most part, I probably won't be spending as much time with the unchanged pieces, the unhighlighted language. But if for some reason there's something there that you wanted to ask me about, feel free to jump in, slow me down, go back to one of those unhighlighted parts, and we can talk about that too. But that's kind of the general way I'll approach the walkthrough. And also to refresh the committee's recollection about the big picture here. Remember, there were, as is often the case, three major points that were involved in the original bill as introduced, H578, the animal cruelty. It has to do with the crime of animal cruelty, right? You have two different potential offenses: a misdemeanor animal cruelty offense, a felony animal cruelty offense. Misdemeanor is generally a 1 year max, 2 year for a second offense. Felony is 5-year felony if it's aggravated. That's what you have on the books right now. The three sort of main changes that went on with H578 as introduced, and there's a lot of things, but these are kind of the big picture, three things. It expanded the definition of sexual conduct with an animal for purposes of the crime of animal cruelty. So as it is, the sexual conduct piece has some elements. It expands it in a number of different ways. It adds some additional types of conduct. It makes it a felony when it's done in the presence of a minor, that sort of thing. So that's one of the three. That one is the one that has the least amount of changes in the amendment. So there's some little things you'll see. There's some tweaks and a couple of things added here and there. But for the most part, that's going to be the one that we go through the most quickly. So that's number one. Number two is, you may recall that in addition to the criminal sanctions, the misdemeanor felony stuff, that a court may impose when someone gets convicted of one of these animal cruelty offenses, there's also a list of other types of sanctions that aren't criminal in nature, but it could be, for example, the person's prohibited from possessing the animal that was subject to the cruelty, or any other animal that the person owns or possesses or has control over. Or an additional one can be that the court could say, we can't possess any other animals in the future for a certain period of time. I think it was a five-year minimum. And there's a number of those other sanctions, but the key point to remember here is those sanctions are discretionary for the court, right? The language says may. In other words, the court could choose to impose some of those other sanctions, but it might choose not to. And that's the existing law. That's not the amendment. That's the existing law. Remember, then one of the major changes of H5 of the bill as introduced that we went through was it made that may a shall. So those additional sanctions would no longer be permissive or discretionary. They would be mandatory. The court would be required to impose. So that was H578 as introduced. The amendment you're looking at now kind of takes a middle ground. So it keeps some of those sanctions will continue to be discretionary, as is the case under current law. But some of the others will become mandatory. That's proposal. And those primarily involve possession of the animal or possession of any animal, because you have two different prohibitions that the court can impose there. And whether or not it is permissive or discretionary or mandatory is generally going to turn on whether that offense was a first offense or whether it was a second or subsequent, and whether or not that offense was a misdemeanor or whether it was a felony. Now, there's going to be some detail in there that we'll go through when we look at the language, but that, I think, it's a big picture, would be helpful to just keep in mind. Yeah, that's what's going on with that. That's the structure it tries to set up, that sometimes those sanctions will be discretionary, sometimes they'll be mandatory. Generally, will turn on whether or not the offense was first time or not, and whether or not it was a misdemeanor or felony. All right, so that's topic number 2. Topic number 3. Now you may recall too that that when there is a probable cause to believe that an animal is subject to cruelty, the animal can be seized by an animal control officer. Now, that's generally a law enforcement officer, or it's a humane officer, and the humane officer is ordinarily a law enforcement officer or a municipal animal control officer. So they can seize it either with or without a warrant. If they get a warrant, they tell the judge they have probable cause to believe the animal is being abused, or if it's an emergency situation and they think there's a life-threatening condition for the animal, they can seize without a warrant. In either case, it might be that criminal charges will be brought against the person, right, under the misdemeanor felony statutes that I just mentioned. Or it might be that the animal could be subject to a civil forfeiture proceeding. Not necessarily true that they would file a crime. They might not, but you could also, the state and the officer could file a petition for forfeiture of the animal civilly. You have a lower standard of proof. You have a different, it's in the, not subject to the beyond a reasonable doubt. There's differences between civil and criminal. But either way, you think about it, either way, if the animal gets seized and one of those 2 court proceedings is going to happen, and somebody's going to be providing care for that animal in the meantime, right? In between that moment that it's seized and however long it takes to get that court proceeding resolved, somebody is incurring expenses to feed, to provide care. Many times in these cases, there'll be veterinary care that's necessary. So all that stuff that accumulates over that period of time, somebody is paying. So that's this third issue that is sometimes called cost of care. You sort of describe it generally. And as introduced, remember H578's approach to deal with that was to create this separate cost of care action, this civil action, so that the organization that has custody of the animal or the state can file a separate civil action against the owner and get payment from them, get the court to order payment from them of the cost of care, totally separate action. This amendment that you're looking at doesn't touch that, leaves that alone. You may decide you want to keep it or not, depending on what you think of the alternative approach that the amendment takes. And the approach that the amendment takes is, instead of getting into that separate action, instead amend and attempt to expedite and move forward more quickly the existing civil forfeiture provision. So instead of creating a new action, it attempts to get at the same issue, which is these accumulating costs. And you think about it, if you can expedite that civil forfeiture proceeding, make it go quickly, more quickly, then the amount of cost is not going to be as much, right? Because the animal won't have to be cared for as long. So that there's that piece of it. In addition to that, it also includes a requirement that the owner pay security if they're going to have a hearing and contest the forfeiture. So you see, that's to address the cost issue in a different way. You have one way, if you can tighten up the hearing, then there will be a smaller amount of cost in the first place. Second way as well, there's always going to be some cost. So is there some way you can put in a procedure or some mechanism that allows those costs to be compensated more directly, more easily, really, without requiring the separate court process, like the cost of care action. And the way it does that is it requires payment of a bond. So somebody gets their animal forfeited, and the way that you sort of think for a second how that's going to work, they can request a hearing, which is certainly constitutionally required if you have your property seized by the government. But they also are required to pay a bond. And you'll see when we get into it that this bond payment is there's, by rule, the new Division of Animal Welfare that you created last year creates rules to say how much is this payment going to be, how's the payment schedule going to work, all that sort of stuff. That's the mechanics of it. We can get into that later, but that's the big picture. So that's the approach that the amendment takes. Streamline to the extent possible within constitutional limitations the forfeiture process and provide for payment of a bond to try and compensate for cost of care expenses. That's sort of bucket number 3. Sexual conduct, the mandatory versus discretionary sanctions, and how to recoup the costs caring for the animal. So that's the big picture. I can pause there for a moment, or we can jump right in and start looking at the language, whichever the committee prefers.
Let's jump in.
Sounds good. Thank you. So let's look first then at topic number 1, which is the definition of sexual conduct. You'll see that right there on page 1 of the amendment. You'll see no highlighting here, so there's no changes on this particular page. But one thing to note here is that on page 1, you'll see lines 15 and line 18. When conduct is prohibited because it's defined as sexual conduct, there's an introductory clause without a bona fide veterinary or animal husbandry purpose. So in other words, sometimes some of this conduct might actually be for a legitimate veterinary reason. For example, like an artificial insemination situation or something like that, that is going to involve some touching of the animal's sexual organs, right? And you're not attempting to criminalize that here, or neither was the existing statute. So I think this is really primarily a technical change. When the bill is introduced, expanded the definition of sexual conduct to include, over on page 2, look at the unhighlighted language for a second, any intentional transfer or transmission of semen by a person upon any part of an animal, neglected to include without a bona fide veterinary or animal husbandry purpose. So that's just repeating language that already exists in other places. I think that's really was an oversight that language wasn't there in the first place. So that's the only change there. All right. So another thing that the bill as introduced did, you may recall, was expanded this definition of, and I'm over on page 4 now, expanded this definition of sexual conduct with an animal in another way, which is to include visual images, to include the possession, film, or distribution of visual images of sexual conduct with an animal. Essentially, it's talking about pornography involving an animal, essentially. And so that was added. No change to that. That's line 14, page 4, sorry, line 15, page 4. But it does add, so the proposal in the amendment is to add another instance that would also count as animal cruelty. And you see that's number 12, page 4. And this conduct that would be prohibited would be constitute animal cruelty. It's possessing an animal while the person is prohibited from possessing an animal by a court order issued under the statute. So remember, as I was saying in the beginning, one of the sanctions that a court can impose for animal cruelty is an order that the person not possess an animal, or either the animal or any other animal that was living with the person, or any other animal for a certain period in the future. If the person goes ahead and possesses it anyway, then they're violating that court order, which probably could be prosecuted as contempt as well. But this specifically adds a provision that if the person does that, that also constitutes animal cruelty.
Do you want questions now or just?
Maybe by section. So yeah, go ahead.
Yeah.
Perfect.
Yeah.
I have one too, but go.
Just thoughts on just expanding it to possessing an animal when prohibited from possessing an animal by a court order.
Yep.
And just cutting out the pursuant to subsection 353B. So it would just be like any court order that prohibited animal possession. So if you had like a condition of release or a probation condition in a criminal case, and then you possess an animal, then they could bring an animal.
Maybe some kind of anti-stalking order, RFA.
Yep.
Because even could have that in it.
Yep.
Yep. Yeah, I think that also would work. Yeah.
Yeah, no, that makes sense.
Okay.
Yes, Barb.
So I'm wondering about possess. If somebody has their friend's dog visiting them, they don't possess the dog, but they may be with the dog. And maybe they're even watching the dog. They don't possess the dog.
Right. And so are you thinking that you want to, is the idea that you would want to make sure that conduct was prohibited? In other words, they couldn't do that as well, or what?
Right.
I mean, where were you hoping to go?
I just would hate for it to be somebody saying, "Oh no, it's not my dog. It's my daughter's dog. She's in Florida and I'm watching it for a week."
Yeah. And in fact, I think another way, and I should have done this in the first place, so thank you, that's a good catch. If you look, because the way it's phrased now, and I know as Representative Goodenow said, we're going to probably strike that reference to specific court order issued under 355(3)(b), but you could just track that language, which you can order someone not to any animal owned, possessed, or in the custody of the defendant. So if we just track that language,
Possess or care for.
well, right now, you could do that. It's in,
Workplace.
I'm looking at, B1 and A under the amendment, page 8, line
Yeah.
13.
Line 13.
So the court can order, any animal owned, possessed, or in the custody of the defendant. But on the other, I don't think there's careful. Oh yeah, it's also in the, for the future, right? You're right, it's careful over page 9, line 7. So in the future, it uses the care for.
Right. Because somebody could be fostering and be like, oh, I can, I just
Right.
thinking.
Yeah, no, that should expand, because, I mean, it's supposed to be picking up what we're prohibiting,
Right.
and that's not dispossess, so.
Right.
Yeah, yeah.
Yep, nice catch, thank you.
So while we're at it, I'm just gonna flag an issue that would like legislative council to look into a little bit further. And that's with respect on page 4, line 15, 16. In reading State v. Van Buren for the voyeurism case, it references a case, Stevens, where the court emphatically refused to add depictions of animal cruelty to the list of categories of unprotected speech. So there may be a First Amendment problem with respect to that line 15, 16. At least I just want you to look into that.
Okay. Will do.
Just to flag that for.
Right.
To make sure.
You have a site on State v. Van Buren?
I'll find the.
I have the case. I can forward it.
Okay, great. Thank you very much.
I'll find the Stevens case.
Okay. Yeah, I've heard about it.
First one, okay, what now? Sounds good. So we'll look at that issue, the First Amendment issue with respect to G. Have some new language that we just talked about for subdivision 12. Going to move on unless there's anything else here. All right, so remember I mentioned that one of the ways in which the bill has introduced expanded the definition of sexual conduct with an animal was it also provided that if a minor was involved, either participating or observing, then it repeated all that same sexual conduct language, and but if for purposes of participation or observing by a minor, it became a felony. Right, so it's a 5-year felony in that case, and that you see over on page 5, lines 7 through 20. So that all that language just repeated the same language that you already have for purposes of a misdemeanor. Not involving them. However, again, I think just a matter of oversight, as we were just talking about, we'll probably come under the same First Amendment analysis that Chair Lalonde just mentioned. The addition of visual images in the misdemeanor section was not repeated in the felony section when a minor is involved. I can see that. So if you look at page 6, lines 4 and 5, it's just the same language from the misdemeanor, except adding in the presence of a minor or in which the minor participates, it makes it a felony, the same way you did with all the other sexual conduct offenses. Again, primarily technical, with the exception of the First Amendment approach, more than technical. Yes.
Yeah, that one might not be as much of a problem. You have the minor in there.
Yeah, that's right, exactly. All right, so that is actually the end of the first bucket, the definition of sexual conduct bucket. So I'm going to move on to the second one, which is the additional sanctions that the court has the discretion to impose, or at least has the discretion under current law. And under the bill, remember, it became mandatory. Court shall impose these additional sanctions. And as I mentioned, the proposed amendment takes kind of a middle ground, some mandatory, some discretionary, depending on whether it's a first or second offense and whether or not it was a aggravated or misdemeanor. So a couple of instances where you can see this distinction starts on page 8. So you'll see this is in existing law, page 9. Line 9 at page 8. You see, in addition to any other sentence, the court may. See that may in line 9? This is important because what flows under that subdivision, under B1, is going to be the list of discretionary sanctions. The court may. Just for a second, turn over to page 10, line 12. Now, if you look at that line, it says, in addition to any other sentence, the court may impose, the court shall. Everybody see that? That whole subdivision is new. Because what we're doing is bifurcating these sanctions into some permissive ones and some mandatory ones. And we're doing that in these two different subdivisions. I'm just sort of outlining up front. So you can say, okay, here's the may, and the shall is going to be over there.
Wait, what line is that?
The second one?
Yeah, the second one.
On page.
Page 10, line 12. Yeah, you'll see the shall was the very last word of that line. The court shall.
Took me a long time to find it, but there it is.
That's all right. There's a lot of language here.
Thank you.
Yep. Okay, so turn back to page 8 though. So, all right, so which ones are the discretionary ones? What does the may cover? All right, first of all, now we're talking about possession of the animal that was subject to the cruelty or any other animal that might be living with the person owns or controls. So that's what we're talking. That's this first category here. So for that situation, you'll see line 12 for a first violation. All right, so we're talking about first violations here, and that is one of the main reasons that this language is here under the may, right? It's a may because it's a first violation. So if it's a first violation of one of those animal cruelty offenses, what can the court do? They can order any rights to the animal subject to cruelty in any other animal. And you'll see that except livestock or poultry exception is preserved. It's just moved to the next sentence because I thought that it reads poorly. It's difficult to understand what that means. Any other owned, possessed, and it adds on line 14, you'll see not just can the court order the person not to possess the animal subject to cruelty or any other animal, line 14, owned, possessed, and then you've added residing or domiciled. So that was an addition to make clear that any animal that is either domiciled or residing with the person can also be ordered. Now, probably that would likely come under the second language in the custody of. It's probably some crossover there, but just to be sure, the language is added.
So in the case of the person who was watching their sister's dog, is that
Temporarily, you mean? Say they're watching, or
temporary?
maybe even for the day while the sister's at work.
The day the sister is homeless and they're whatever.
Yeah.
Would that animal either be subject to this or return to their owner so that they're not forfeited?
Well, the animal isn't forfeit, it's the person
Right.
forfeits their right to.
Right.
So I would say that would come under in the custody of the existing language there. That animal is in that person's custody for that period of time. And I would say, yes, if the court, now remember, this is discretionary.
Yeah.
But if the court did order, hey, you can't possess, you can't have any other animals in your custody while this is going on, I would say that counts as custody.
You wouldn't want the other person's dog to be abused.
Right. Yep. Sure. Now, as I mentioned, this order that the person can't possess any other animal, other than the animal who was being abused, as an exception, line 13, except livestock or poultry. I think probably the idea is there, for example, someone who's a farmer may have abused a dog, but I think that the intent probably of that exception, I wasn't here when it was put in there, but sort of thinking about what it might intend is that doesn't necessarily mean that the court could order the farmer to not possess any cows, for example, if they're running a farm. So with that, but that was unclear the way it was written as to how that clause applied. So rather than keep it there, just put it out into a separate sentence and say, livestock or poultry shall not be subject to forfeiture under this subdivision A. So generally, they are accepted unless, or an exception to the exception, unless the person was convicted of abusing livestock or poultry. So if that's the type of animal that the person abused, well, then the court might order them not to possess any animals.
Then it's not a first-time violation.
No, it's still a first-time violation for this. This is only for a first violation. So you'll see the language does come in subsequently for a second or subsequent.
So, but this is the conviction for the first.
Yeah, it's the first conviction.
Right, okay.
Yeah.
But if they are doing that, abusing the livestock because they have a prior conviction, wouldn't that part?
It's not a prior conviction. It's the conviction. If you look up at line 10,
Okay,
these are requirements that go along with that, follow the conviction. You're right, though. If they had one and add another one, then you're not going to be under this. You're going to come under the mandatory one on the next page.
like a game board, skip to
It
the,
is, yes.
so jump into that.
Right. So skipping to the next spot on the board, and we'll go over to page 9. Now we're talking about the future right. Right. That was all the animal that's in your possession now, or that you own, or that you're under that's under your custody at the moment. This one says, all right, this talks about if you see line 4, page 9, any future right to own, possess, or care for any animal. And the court also has the authority under this list of sanctions to order the person not possess any animals in the future, or for a period of not less than 5 years. That's line 5. That's the existing law. That's what the court has the authority now. So again, we're bifurcating this out a little bit, but you see what happens here. This is for a first violation, line 3 for a first violation. Then how does it work for the court's authority? Well, what the court can do is, and it depends on whether it's misdemeanor or felony cruelty. For misdemeanor cruelty, which is lines 3 to 5, court can order the person not to possess for a period of up to 5 years. You see line 5. So that's the way it's going to be. Going forward, it's a misdemeanor conviction. It's say up to 5 years. Can't be more than 5, and it doesn't even have to be 5. It doesn't have to be at all, really, because it's discretion. But let's say it's a felony. Then you go to line 6 and 8 for a first violation of 352A. That's the felony. Then they can order for that the defendant not have an animal for any period of up to 10 years. So there's a longer possible maximum for them if it's a felony conviction. And lastly, you see lines 9 to 11. That's just a repeat of the language you just saw. This is the livestock or poultry exception and the exception to the livestock or poultry exception. So,
Go ahead, Angela.
I have a picky language question.
Mhm.
Does it need to say future right to own when you're talking about a period of up to 5 years? It's just a right to own, right?
I think you're probably right. Technically, I would be a little hesitant because of the court's general rule when interpreting a statute saying we presume the legislature had an intent in doing something. So you strike the word future.
Double up on the intent. Are you keeping future?
In other words, future is existing law. You strike it here.
And
It's sort of be unpredictable what the court might say.
Okay.
But that has been the language for many years. So
Too bad I wasn't here when it.
so we can make it retroactive, maybe.
It's redundant.
Yeah, it's true.
Fair enough.
Carry on.
Right. All right. So now we're moving over to, so we've gone through the first offenses. Oh, sorry. Before we get to the second offenses, so we're over on page 10 now. We're at this, remember, so now we're still in this list of other sanctions the court may impose for animal cruelty. The amendment also proposes to add one. In addition to this thing that we're talking about now, about the amount of time they can be prohibited from owning, whether it's a felony, misdemeanor, et cetera, it also adds one more category, page 10, lines 5 through 11. So the court could also order that the person be prohibited from working in any capacity that requires the person to be in contact with an animal. And then it lists some examples. It's including, but not limited to, but it gives some illustrative examples at a commercial boarding or training establishment, shelter, animal control facility, pet shop, grooming facility, et cetera, or any nonprofit organization or incorporated for the purpose of providing for, promoting the welfare, protection, and humane treatment of animals. So another thing the court could order, again, it's not required, discretionary, court could order that the person be prohibited from engaging in that kind of work. That's the proposal.
Margaret's question.
So So could somebody work at a for-profit organization that is promoting the welfare of animals?
I think the idea is that some of those are, pet shop,
Right,
commercial breeding service, I think those.
but there might be a for-profit, there might be a for-profit that, might be a nonprofit that has a for-profit component.
Right. I would say that you could list that if you wanted, totally up to you, but I also would say that these are only illustrative examples. So if you look at lines 5 through 6, it's prohibited from working in any capacity that requires the person to be in contact with an animal. So I think that would be included, but that doesn't mean you couldn't add that if you wanted to the list of examples.
And there are all these services like Rover, I think, that are like where you're sort of an Uber walker for a dog. And so I don't know if it's also, if we need to talk about dog walking, because you're a self-contractor. And if those companies aren't asking, have you been, and I don't know if they are, but if they're are they saying, would they need to say, have you been convicted of animal cruelty? Because if somebody's walking your dog, it seems like they have incredible access and maybe not the typical, they feel like they're not as regulated.
But so, I mean, it's the working in any capacity that really covers a lot. Are you suggesting that there's certain companies that haven't checked the background? I don't know if any of these companies necessarily check the background. Hopefully they do, but I don't think
Humane Society, I think.
Humane Society might.
But I don't know if we need to include for-profit or as a independent contractor, you can't work, because somebody might be like, oh, well, I didn't know I couldn't be an independent contractor and walk dogs. And or like, and those people also are like dogs, like you can hire them if you go on vacation. So somebody having your pets to themselves for 2 weeks would be.
If you want to be clear on that point, on line 5, you could say, be prohibited from working in any capacity, comma, including as an independent contractor, comma, and then go on to the rest if you want to just be 100% sure that that group was covered.
I'm just wondering, do we want a violation of subsection F to also be a new animal cruelty charge?
Oh, you mean add to the,
So I think right now,
or add to the possesses and that, on page 4, line 17, 18. Well, just add word list.
Yeah.
Which
does that satisfy that?
therefore all the list. All possesses, cares for, resides with, works with, all those.
And that way, yeah, and then it covers it.
If you're prohibited from all those things under a court order, that violate the animal septic
Should I put that and all the others?
and all the others. I'll leave that to your legislative drafting standards. That's to say that.
I think that makes sense. All righty. So we're moving on now to the second or subsequent offenses, animal cruelty offenses in the court. In this situation, remember I mentioned this before, let's look at it again, page 10, line 12. For second or subsequent offenses, these other sanctions become mandatory, right? See the shall, last word in line 12? All right, so again, we're in the same group of offenses. The first one is also on page 10. This is the forfeiting any of their rights to the animal that is subject to the cruelty or any other animals that live with the person. Second or subsequent violations, again, you have the livestock exception, lines 18 and 20. So again, the difference here is that the court doesn't decide whether or not you forfeit your rights, it's shall. So second or subsequent offense, that animal is forfeited and, or sorry, not the animal is forfeited. Your right to own the animal is forfeited, as is your right to care for, have animals, custody, et cetera. All right, so what about the future property rights. That's over page 11. Again, second or subsequent violation is broken out into the misdemeanor or felony. Lines 1 through 3 is the misdemeanor. So if it's a second or subsequent violation of the misdemeanor animal cruelty statute, you are prohibited from owning an animal in the future or any right to own, possess, or care for a period of not less than 5 years. That's line 3. So that's different. That's not up to 5 years. That's a 5-year minimum for purposes of a prior conviction. Again, lines 4 through 6. What about a second or subsequent violation of the felony aggravated cruelty statute? In that case, you're forfeit any right to own an animal in the future for a period of, again, line 6, not less than 10 years. So you got a 10-year minimum if it's your second felony violation or subsequent. And again, the livestock or poultry exemption language is repeated line 7 through 9.
So back on page 10, subdivision F, I think subdivision F should be tied to those periods of time that we have, the May first violation that, there's a time limit to that prohibition on working with animals. There's the same 5-10 year, and also the same with, the second or subsequent. Yeah, I think the working with is kind of with the care for, residing with. Maybe, and I once again leave this to drafting conventions, maybe it just says working with, and then we separately define in the definitions section what we mean by working in the capacity.
Yep, that could work.
That might be easier
It
to,
would
Right.
need to go, yeah.
Right.
but do people agree? I mean, I think that was the intent, was that you're not allowed to possess. It was expanded to, any kind of contact with animals for that period of time.
And we're not expunging it. So if somebody is applying somewhere, probably some organizations might say, have you ever been convicted of? And so they may set their own thing, but that's fine. The court isn't making it. Right?
I'm not trying to
So
understand.
if you wanted, after your 5 years is up, you wanted a job at the Humane Society or to volunteer there, you might still have to fill out an application that asks you, have you ever been convicted of,
Oh, right.
and which you would say yes. And they are allowed to say, we don't allow people who have ever been convicted,
Right.
right?
Yeah.
Nothing precludes
Yeah.
that.
Yeah. No, nothing would. Yeah,
Right, okay.
Right.
As long as.
Right. I see what you mean. Yeah.
Yeah, okay.
Yeah. Angela.
Thank you. I am wondering if on page 10, lines 16 and 17, to mirror the language on page 8 for the first violation, we should strike except livestock or poultry.
Oh, right.
16, 17.
Oh, yes, nice catch. Thank you. That should be struck.
Right.
All right. We're now moving on to a separate process that's supposed here, lines. I should say it's separate, but it's very much related. Page 11 through 13. This creates essentially, I think Representative Burdick might have been one of the people who was asking about this. This is adding a process for a person. So as we're just talking about how a person can be prohibited by court order from possessing an animal, either presently or for a period of time in the future, right? So court can order that. This creates a process. So if the court does order that, the person can petition the court for an order, asking that they essentially be relieved of that prohibition on possessing an animal. They could do that at some point in the future if they choose to say they're under that 10-year, or actually, I think that was a minimum. Say they're under, some period of time that the court's ordered that they can't possess an animal. The person can file this petition in court and ask for a judicial review of whether or not they ought to be allowed to possess an animal at that point in time. So I should tell you, just so you know, this language and the concept is based on something that's already in statute with respect to firearms. So you have the petition that can be filed if someone is prohibited from possessing firearms, in particular because of their interaction with the mental health care system. If they've been involuntary subject to mental health treatment, that person actually prohibited under federal law from possessing a firearm. And And there is a piece in Vermont law that allows someone who is prohibited by state mental health law from possessing to file a petition with the court and get the court to say they're no longer a danger to themselves or others, so their firearms rights can be restored. This is modeled on that approach. It's a similar idea because you have a court order in place saying you can't possess an animal. This allows the person a process to have the court say, to make a determination if it's appropriate that they can possess. So how does that work? Generally, you see that they can file the petition, bottom of page 11, asking that they be relieved from the prohibition. Over on to page 12, they have to provide notice to the prosecutor, so the prosecutor has an opportunity to contest if they want to. It's filed in the criminal division where the offense or adjudication occurred. Subdivision 2, page 12. The court doesn't have to have a hearing. If the prosecutor doesn't object or if the parties stipulate, they can just go ahead and grant it if they want to. That's also modeled on an option that's available in the firearms context. I listed some factors that the court may consider. You see page 12, it's a non-exclusive list, lines 14 through 20. Again, this doesn't exist. So I was thinking what factors might be appropriate. You may wish to either strike some or add some others. Obviously, the ones, there is a comparable list in the firearms statute, but none of them really translate to here because that's a different situation. So the ones that I have now, it's obviously subject to any change you want to make, whether the person committed any subsequent animal cruelty offenses or other criminal offenses, whether the person successfully completed any required conditions of probation, whether the person participated in prevention or educational programs or obtained psychiatric or psychological counseling. And again, these are just factors the court may consider, and it's a non-exclusive list. So just examples. So,
Yeah.
Just a quick question about what, one of those conditions, B, on line 16 and 17, whether the person successfully completed any required conditions of probation, would the court interpret that to mean conditions of probation related to just the animal cruelty conviction or case, or probation including other?
that was certainly the intent. So you may be right. You want to include that specifically. Yeah.
Alternatively,
Or
the
not?
court considering, the defendant's on probation for something else and has like a bunch of violations of probation because they're not complying. That may be something the court could consider.
Mhm.
And,
Yeah,
Right.
yes, I think I'd want to be clear about which one it is, though,
yeah,
what the expectation is.
I think if it says conditions of probation as it is right now, it's the broader.
And it would be interpreted that way.
Yeah, I
Okay.
would think so. It's not tying it
With that.
any required conditions of
Yeah.
probation.
Get Jamie, how you interpret it.
Like he won't tell us because
and it's just examples, right? So it's like,
Yeah.
yeah.
I just wonder if that's an unnecessary point of confusion.
Yeah.
If a petitioner is assuming one thing, but then the court that another way. I don't know.
Let me throw in my 2 cents.
Yes.
I tend to agree with Representative Arsenal because I look at A and B. Next up. Because in this case, I look at A also. And just imagining how it would be interpreted. A, you specifically said whether the person committed any subsequent animal cruelty offenses or any other criminal offenses. So the court might say, well, if the legislature intended to include any other probation for any other offense, you would have said so, the same way you said so in A.
Yes. Of course, we are missing the word "or" on line.
Yes, I noticed that. Did I write in there? I caught that.
You too.
Yeah, that's right.
So, the language as far as the court may consider, does that mean they can't consider anything else? Or is that understood that this is just some of the things they can consider?
That is understood. It's non-exclusive. Exactly.
Right. Point for Angela. Yeah, Barbara.
Eric, I have a tiny question about page 12, subsection 2, line 6.
Just one, sorry, Representative Anderson, I'm just finishing jotting this down. All right, sorry, go ahead.
So
Where were we, page what now?
Page 12, I'm sorry.
Okay.
Line 5 and 6.
Yep.
I'm just wondering, we said that they need to give notice to the, they'll provide notice to the prosecutor. Does that include notice to the Attorney General, or there's some automatic way the Attorney General is looking at every petition?
No, it would just be whoever, because sometimes either one of them might be the prosecuting officer in a given
Any
case.
underlying.
Right.
Okay, so it is not that the Attorney General is going to weigh in on every case?
Correct.
Okay.
All right.
So yeah, and then you have some more language about how that proceeding works, where the person files for a request that they be allowed to. And really the language that maybe I'd point the committee most to is over on page 13, lines 2 to 4. Because that is sort of the standard. When does the court grant this petition? And again, that was, since this doesn't exist, I was thinking what makes some sense, but maybe either it doesn't, or you want to change that, or whatever. But the way I put it now is that the court makes a finding that the petitioner is no longer likely to abuse an animal in violation of animal abuse statutes. That might be one way that the court would say, okay, in that case, you're not prohibited from possessing anymore. But there may be some other standard that you think might be better.
So that no longer likely to abuse
Yeah.
language kind of stuck out to me a little. I'm curious is there language like that in the firearm petition stuff that you sort of mirrored this on?
It's similar. It's not, the wording isn't the same, but in the firearm statute, what the court has to find, and this term is defined in mental health law, to find that the person is no longer a person in need of treatment. But in mental health law, in a nutshell, that means they're no longer likely to harm themselves or others. So yes, on the one hand, on the other hand, it's a little tighter in the firearms context because that term is defined.
Yeah.
Right. So comparable concept, but
Yeah. I guess I'll see what Zone A thinks.
right.
Yeah.
So if the petition is granted, subdivision 5, lines 5 to 7, then if the court grants a petition, then the prohibition no longer applies, so they can go ahead and possess an animal. Subdivision 6, it's appealable to the Vermont Supreme Court. Court reviews it on the record, de novo. And lastly, this is also directly from the firearms piece, lines 11 to 13. This is to prevent multiple successive petitions. So a person gets denied, they can't 2 weeks later file again. They can only file, they have to wait a year if you get denied.
Sorry, one other question.
Yeah, go ahead, yeah.
Eric, what is there sort of a process for deciding whether something should be de novo or not for appeals like this?
I think, I'm not sure, there probably is some sort of fallback rule, some, general rule. I think, I know that legal questions are generally reviewed de novo, whereas factual questions, they generally defer to the trial court. But I don't know if the court has sort of a handy rule of thumb that they use for which is which.
Yeah. Okay.
Were we adding, work with, like the own, possess, care for, that phrase that we're repeating?
Uh-huh.
Or is that what we were adding, also work with and all the conditions? Do we have to repeat all of that where it says
Where are you?
line 5, page 13, lines 5 through 7, if the court shall enter an order declaring that the order prohibiting the person from owning,
Right.
possessing, or caring for,
So
we have
line
to
6 and 7 needs to be consistent with what we're.
whatever
The work.
that bulky little phrase.
Yes, and we'll need to add that in a number of places.
Yeah.
Over on like page 11, line 18, 19,
Yeah.
for example. If you want to include the ability of the person who's filing this petition to obtain an order that says, okay, you can work with animals now.
Right, yeah.
Right.
Yeah.
All the prohibition.
Yeah. Yep.
Yes.
Sounds good. Yep. All right, so we're now moving on to topic 3. That's the end of topic 2. That was the sanctions, right? The court may impose.
There you go.
But now we're moving on to this. Remember, as I mentioned, this is an expedited civil forfeiture proceeding. And so the idea is to have the proceeding move forward in a more timely fashion. and also allow for some of the costs that are incurred to be paid more easily in a more direct way and at a more early phase of the proceeding. So those are kind of the two things you'll see at work here. And remember again that this all comes into play because a humane officer can seize the animal at the outset, whether or not there's criminal charges filed or not. Because if there's no criminal charges filed, they still can bring this civil forfeiture proceeding. That's proceeding against the animal. In theory, it's not a criminal conviction or any kind of criminal action against the owner. It's only to obtain the forfeiture of the animal. It's a civil, not a criminal proceeding. So there's a number of changes that are made, proposed to be made to that proceeding. And you'll see it sort of starts at the bottom, page 15. It strikes much of the existing forfeiture process. Not all of it. There are little pieces that it keeps. And you'll see as we go along. But for the most part, it strikes the existing forfeiture process and starts fresh. So turning over to page 16, just a couple of things to note. Yeah.
Just to make sure that this is noted by folks that on page 14, I didn't hear you, David.
Oh, you're right. Sorry, I missed
That
that.
we're changing the musts to a shall if practicable.
Correct. And this is the veterinarian accompanying the humane officer during the seizure. Exactly.
And that's the practicability is proven somehow, or?
I think what we heard was that if there was a challenge to the seizure, that would be on the state to show that it was not practical. Yeah, the veterinarian.
Okay. Okay, thank you.
Thank you. Just a couple of things to note as we're going through, just so you can see, because I'm gonna point these out as some of the big changes in the new process. So I'm on page 16, lines sort of 8 through 9 and 10. Some of the struck language there you see. There's different stages of hearing that have to be added under the existing law. So you imagine the forfeiture, the forfeiture, or the seizure, I should say. There might be a time that passes between seizure and when the state's attorney institutes the forfeiture proceeding. So there's a time lag right there. Then after they institute it, within 21 days after that, lines 8 through 9, that's when you have to have the preliminary hearing. Then the defendant requests, there'll be a final hearing 21 days after that. So you can see how those time periods can become very lengthy. So one of the ideas here is to, I said, expedite that process as possible. You also see on line 16, line 20, the current burden that the state has is clear and convincing evidence. The proposal here is to go with a more moderate burden of preponderance of the evidence. So more likely than not clear and convincing. So it's the middle, it's the standard burden of proof in a civil court action. Preponderance of the evidence, more likely than not. So you'll see that when you go on too. But sort of speaking generally for a second, what are the main changes to this new hearing process? The way it's going to work is that when the humane officer seizes the animal, right at that time, they give the owner notice that they hand him a copy of this section, and they give him a form that they can fill out if they want to request a hearing, and they tell the person, and it's in the form as well, you have 10 days to request a hearing. And if you don't request a hearing within that 10 days, then the animal is going to be forfeited. So the person has the right to request a hearing if they want it. So you have that constitutional right, but they can choose not to. And if they don't, then the animal would be forfeited. Additionally, at that time, the person is informed that they have to request a bond. I'm sorry, not request. They have to post a bond. So this provides some security. And the word uses security, doesn't use the word bond, but it's a similar concept, which is that some money has to be posted. And then think about, where's that money go? The way the proposal is, the money gets posted with the court, but the court doesn't have to do anything at all with it. Remember, that was, I think you may recall, that was something Judge Zone was concerned about. Instead, the money just goes right to the Division of Animal Welfare. And they're going to be the ones who manage the distribution of it to the custody organizations that incur the costs, that sort of thing.
If they can't afford to post a bond, they're not receiving the same due process as somebody else might. They couldn't pay for the bond. So how does that be addressed?
that is an incredibly astute and excellent point. The same point that I thought of last night. And so the answer to that is yes. If the I'll move on to how we address. But yes, you're exactly right that if a person is required to forfeit their property simply because they cannot pay the security, cannot pay the bond, that is almost certainly unconstitutional. That's a due process violation. And that's essentially penalizing somebody for not having the ability to pay. And though they don't get the same due process, so it's both a due process and an equal protection violation, according to the research I did. So, however, there's a way around that. And the way around that.
I was afraid of that.
And the way around, I should say way around, there's a way to address. And that is if you turn to page, let's see here. Page 24, lines 3 and 4. So, the security required by this section may be reduced or waived by the court on the basis of financial hardship to the defendant. So, courts seem to have said, at least the most recent decision I was looking at, that an ability to waive the required payment in the case of financial hardship. And that way you provide for the ability of someone to request a hearing, and they're not going to be having their property forfeited just because of their financial hardship. So that's the idea of having that language there, is to cure the due process issue, or at least improve it.
Inform the proper response.
Same idea.
Karen.
So is there kind of like a set process that already exists to do that? I mean, like who's determining the financial hardship, and is there a form or?
Nope.
No, so
That's
that would
the
all
court.
need to be
It's up to the
created.
court.
Okay.
Well, yeah, I mean, it could be created on the basis of decisional law, and the court could turn to other things. For example, there's a list I know of factors that are used in the context of the public defender statute. So the court could conceivably look at that, but nothing laid out here. Sort of gives the court the basis to make a finding, a financial hardship and waive the fee.
Yeah, go ahead.
Just a drafting question, I think like a style question. Is there any way, would it be out of the ordinary to actually move that language from line 3 and 4 on page 24 closer to the introduction of fish security?
The reason that it's not done, you can do it, you can repeat it twice, is because there is security language at both the trial court proceeding and the appeal proceeding. So rather than put it in both places, I just put it. Well, you can if you want, certainly, if you think it'd be more interesting.
I mean, I'm just wondering, like, I guess I'd be curious to know how practitioners use and Vermonters reading statutes. I don't know how many Vermonters are reading statutes, but it's just interesting to get all the way through this going like, oh my God, no, I can't pay this, I'm screwed. And then it's like, oh, by the way.
Well, it's
like the big reveal.
It's at the end of the story.
Right.
That's one way to think of it. It's
Yeah.
like,
The big reveal.
I have a suggestion. I have a suggestion.
Karen, yeah.
So looking at, I agree with that, looking at page 18, I know we're going ahead, but it's saying what needs to be included in the notice. I'm wondering if there could be an E or something that says, and include the ability to apply for financial hardship. Like, something like that.
right,
Yeah, you certainly can.
Yeah.
right there, maybe with C where it says a statement of the amount due as security and how to pay it, that could include language on.
Right.
Or how to, petition, I don't know, if petition's the right word, but
They fill out ability to pay for it all day long.
Yeah, something like informing they can request.
It's on the notice.
Right.
And also in where it is on page 24. Be good. I have one other question about this section, but I want you to red line.
Thank you. Okay, go ahead.
So I'm wondering just what's the universe of people who might claim a legal interest? Too many.
Animal might be owned by more than one person, maybe it's
Yeah.
family, maybe it's spouses, maybe it's an animal that's.
So that's something that's understood or.
Yes, right, exactly. Yeah, sort of that legal interest formula or language rubric, I should say, is something the court's very familiar with. So, yeah. So that's that so that's sort of the security discussion that we were just having, and that so the person has 10 days to request this hearing and to post the bond. Post the security has to be done all within 10 days unless they have this financial hardship extension. And if they do request a hearing, if they do within that 10-day period request, it has to be held within 30 days. And then, as I mentioned, the Department of Animal Welfare holds the security, and then that all is laid out on pages 17. Actually, you see on page 17 too that unless this happens, it's line 7 through 9. This is sort of, again, trying to streamline this process. Unless if the person doesn't request a hearing and doesn't post the bond, assuming they don't have hardship, lines 7 through 9, title to an animal shall be forfeited pursuant to this other section of the pre-existing law about title. So if they don't do those things, you don't request a hearing, you don't post a bond, title's forfeit to the state. So again, trying to both minimize the costs by reducing the amount of time, and then also provide for payment of security to offset the cost of care.
This is minor, but maybe this doesn't make a huge difference in this context, but I always have day is a day in the back of my mind and have things 7, 14, 21. Can we make the 10 days, 14 days? So if your animal is taken on a Friday, you have 2 weeks from this Friday. It's just to be consistent with the day.
Do whatever you want.
The past 11.
Right. Yeah. Sure, that's a total policy decision for you guys.
I mean, this is not quite the same because we're talking about, but maybe the reason for that rule is it makes it easy for people dealing with courts, but I'd be more comfortable with like 2 weeks.
Sounds good.
Generally, anyway, the 10 days seems to be pretty tight.
Where it's just if somebody can believe what happens.
And business day.
Well, that's why I'd say days a day, 14 days.
14 days, that's 2 weeks.
Yeah.
And like,
And you want, there's a lot of 10-day stuff, but you just noted it there.
Right.
But, so you want 10 days, change 14 everywhere, because there's different times at 10 days.
Well, particularly if it has anything to do with filing stuff in court, then yes. I
Okay,
definitely want it to be 14 days because that would be consistent with what we've done with all.
yep. So in other words, like this.
I changed 10 to 14, wherever the heck it is.
Okay.
Or 7 if we wanted to go shorter, but I don't.
Right.
I always find it wonderful that I'm able to bring up the day once in a while. I really do. It warms my heart.
Right.
I'm sorry. It's the small things in life. All right, anyway, go ahead. Sorry to have interrupted.
No, not at all. So when the humane, as I was mentioning, when the humane officer seizes the animal, they provide notice, and we were just talking about what has to be in that notice. We're talking about, we're going to add to that. They have the opportunity to request for financial hardship. But another point I wanted to raise too is on page 17, lines 14 through 17. So if the person is there, the owner's there, they get notice hand delivered. So due process is satisfied. No problem. They have noticed their rights and their opportunity to request a hearing. But what if the person's not there? This might happen. Humane officer sees that there's an emergency situation, and they can remember, because they have the authority to seize without a warrant in an emergency life-threatening situation. Say they do that, the person's not there, they haven't gotten notice because they weren't there. So in that case, that's lines again to make sure that this procedure complies with due process, lines 15 through 17. Any person who is known to claim a legal interest in an animal who is not present shall be served with a notice as provided for by Rule 4 of the Vermont Rules of Civil Procedure. So that means they get personally served. Otherwise, they can't bind them. There's a system in Rule 4. If you can't personally serve them, you can mail it to them. If you can't mail it to them, you can tack it on their door, that kind of thing. There's this sort of series of steps that are all outlined in Rule 4. And that's only for people who weren't there. If you were there and you're served, you don't have to do anything because they were handed the notice face to face. All right, then we sort of looked at this a little bit. What does that notice include? Just, there's some basic descriptive information covered in A over onto page 18. A statement that the person, and this is line 2, they may post a security and request a hearing if they are to do so within 14. See, there's a 10 to 14 there. So letting them know they can request a hearing. They don't want their animal seized. They can go to court and have a hearing. Statement of the amount of security due and a form they can use to request a forfeiture hearing. And now if that hearing request is made within 14, see, I'm on line 3, line 9, page 18, line 9. Court is required to hold this hearing if the person requests it within the time limit. And if they do make that request within the period of time, then they have to have the hearing within 30 days. Everybody see that? And here's another big difference. You see where the hearing is, line 11, it's in the civil division. It's another concern that Judge Zone had. Remember that these things taking place in the criminal division is, first of all, unusual because it's a civil proceeding, not a criminal one. And secondly, there's pretty, as you know, especially clogged docket in the criminal division as opposed to the civil division. So I think, from what I understood from the judge, they will be able to adapt to expedited timelines much better in the civil division than they would in the criminal division.
Makes sense.
Yeah.
I mean, there's arguments against that as well, but I think overall.
Right.
Okay. Yeah.
So I'm wondering if somebody is indigent and wants to have a hearing.
Mhm.
I know the task force on forfeiture was recommending that public defender be appointed if somebody requests it, but it's not current law. So if somebody wanted to have a hearing with this bill
Mhm.
and couldn't afford an attorney,
They would have to appear on their own without an attorney. Yes, if they couldn't afford one. Or they could ask legal aid, conceivably.
We'd be hard pressed to voice this on legal aid right now because
Yeah. they don't really fund it.
yeah, they don't have funding and it's civil, so it can't be defended general. So like 90% of the cases in civil court would be pro se. Maybe it's 99. I think it's like 90%, huge percentage. Judge Zone can correct me when he eventually.
Wouldn't there be a criminal action in tandem with this?
There would, but that wouldn't.
I know it's a separate matter, but oftentimes that attorney will help track both so they know what's going on.
That's.
And also, not necessarily. That's the idea. They're not necessarily going to be a criminal. There could be, there might not be. Next provision has to do with the mechanics of the bond. So we're mentioning the person has to pay a bond. Sorry.
Can I ask one question?
Yeah, go ahead.
The 14-day time for requesting the hearing.
Yes.
If the person isn't served in person when the seizure happens and we're going through the civil rules of procedure for service, when does that 10-day 14-day clock start ticking?
I don't know. That's an interesting question. It might be, I don't know. I'm not going to answer that off the top of my head because I would probably just say something that's completely wrong.
So it looks like we said it starts ticking at the time the animal is seized.
Certainly the case if they are served.
Right, at the time.
That. Yep. Within the confines of due process requirements, whether or not that hearing could still go forward. Because I think personal actual service in every case is not required for due process, as long as it's reasonably calculated to provide the person with notice. So might that mean that the time limit could go on longer for somebody who isn't served? Potentially. But I think I would tend to say whether or not that created a constitutional problem would probably be more of an as applied question, right? I mean, it's not something that would make the statute flat out a due process violation as written. It said, well, how did that play out as far as like, let's say they couldn't serve the person, then they couldn't find the person, they couldn't get him to accept service, or maybe they tried to evade service.
Yeah.
And you can't do that either. All that would sort of have to play out in the proceeding. But I will look at this interesting question generally. I think it probably would sort of depend on how much time had passed.
Yeah.
Whether or not that was an issue. I don't know if there's a flat deadline.
Isn't there a date by which service is considered effectuated by the court? I mean, and that would be the.
I don't know. I don't know the answer to that. It's an interesting question.
Right.
Yeah. Yeah.
Yeah.
Look into it for sure.
Worst case scenario, couldn't you do it at your initial appearance?
Again, this might not have a criminal case attached to it.
Right.
You know that.
Yeah,
So the key here is making, that there has been sufficient attempt for this person to know that they have 14 days to request a hearing, or they are going to have forfeited their.
and my question is just like right now in this, the way we have it written is that 14-day clock starts ticking the moment we see the animal seized. And
Right.
so,
It should be, it's so long as there was service at that time.
and so
It should be connected to
it
service.
should be connected to service,
Yeah.
maybe not seizure. Or, I don't know.
Sometimes it's posting, right?
Posting.
What's the likelihood it's gonna follow a sole civil track, including the animal forfeiture? You know what I mean?
Has to have noticed that they have to ask for this hearing in 14 days, in my view, to protect due process, that they've had their opportunity. They know that they have to ask for this hearing or they forfeited their.
That's why we went to 14 days
Well,
instead
the
of
14
10, right?
No, the 14 days is just a technical how courts calculate days.
Okay.
Yeah.
Thank you.
Yeah, that part's just really mostly technical.
Right.
Okay?
I think so.
So we need to nail that down, that it's attached to service, however, whether it's service at the time of seizure or afterwards.
So in other words, if the person is present and handed the notice, the 14-day clock starts ticking right there.
Right.
Yeah.
Yeah, so we get away from the seizure altogether, and we just do it by service and kind of satisfies. Yeah, because I'm just thinking about like, they're not there, and then the first step is you gotta get a sheriff to do, or a service processor, and that can take a while.
Pretty well.
Right. So that's the sort of category within which there could be that delay. If they're there and served, then the clock starts ticking right away. Yeah. All right, so on the bond issue, sort of the mechanics of it, it's over on page 18, the security. You'll see it sort of lays out that the person requesting a hearing has to post this bond. There's some guidelines for how much the bond is going to be or how long it's going to be. Cover necessary, I'm on line 15, cover necessary food and necessary veterinary care for an initial 40-day period. And then there's subsequent 30-day periods when they're going to have to also post bond. All of that is general. The specifics, you'll see lines 19 through 21 are going to be laid out in a schedule that's adopted by rule by the the Director of Animal Welfare. So the amount of security and the payment schedule shall be set in rules adopted by the Director of Animal Welfare, and that's the Administrative Procedure Act that's being referred to there. So the legislature will get another look at that in the administrative rules process, right? Because they're going to have to propose this by rule, and that'll come back to the legislature. So you have an opportunity to see what that's all about. Security shall be posted within 10 days following the seizure. You see that bottom page 18 over on 19. Again, that 10-day period starts running on which the seized. 14. Yes. And then you see the mechanics again, that last line of the subdivision, page 19, lines 2 and 3. Court collects the security and transfers it to the Animal Welfare Fund, which already exists in law. The legislature created last year. And we have to modify that in this bill because you're expanding what the Animal Welfare Fund can do. And what money they can hold, what constitutes the fund, and that they can make distributions from it for purposes of custody and care of animals that are seized in a criminal context.
So maybe you can't answer this question, but because of the way this is being set up now, does this go to Ways and Means and Appropriations? Or is it because it's a kind of a different?
I wouldn't see it as an appropriations issue because it's not.
I would
It's
double check with them.
Yeah, yeah. And, maybe Ways and Means, because it's, involving the, transfer of the fund, but again, it's not
It shouldn't.
it's really more of a, yeah, it's not.
Right, but I'll nail that down.
Yeah.
Sure.
Don't want to add.
Yeah, we won't let that.
Right. I will note that, I am doing a walkthrough tomorrow afternoon of a different animal welfare bill in House Gov Ops that also has some language about the authority of the, Animal Welfare Fund and the Director of Animal Welfare. So just so you're aware of that. So it's not contradictory or in any way different than this, but it's adding some pieces to the same sections of statute, just so you're aware. So you may hear about that as well.
I'll have to decide if we need to have GovOps look at this thing.
Right.
Thank you.
Yep.
So it's agriculture, GovOps, and who knows what. Say lots of ones. All right, thanks.
Sure. All right, so now we're on to page 19, subdivision C there. Remember, I mentioned this earlier. This is the adjustment of the burden of proof, still on the state. You can see lines 4 and 5. State has the burden of establishing by a preponderance of the evidence, right? It's not clear and convincing anymore. It's a lower threshold, your general civil threshold of preponderance, more likely than not, that the animal is subject to cruelty, neglect, or abandonment, and that just tracks the cruelty. So if the state can show by a preponderance that the animal was subject to cruelty, then the court, lines 10 and 11, court will order the immediate forfeiture of the animal because the state met its burden. So that's the way it works in this civil proceeding. Now, you'll see subdivision C, they're starting on line 12 all the way down to the rest of the page. This is allowing the owner to show that the animal should not be forfeited. And essentially, if you think of forfeiture proceedings in general, whether it's related to automobiles and DUI or motor vehicle infraction context or proceeds of crime, that sort of thing, there is always, and there's a constitutional element to this, there's always an opportunity for the person to show, it's called the innocent owner defense, right? It's sort of referred to as generally. And this is sort of a type of that. It allows the owner to say, hey, look, see line 15, I'm not the defendant in this case. Line 16, I didn't participate in the cruelty. And line 18, I didn't know about it either. So if you can show that, and actually over into 20 as well, and also that they will provide care to the animal if it's released to them, well, then the court can find, oh, okay, in that case, we're not going to order forfeiture. We're going to let this person have custody. And so it allows someone to show and make that defense. So that's that piece. Over from 20, that's just, see, there's no changes there. That's just existing procedures for the hearing, admissibility of affidavits, that kind of thing. Lines 13, that any testimony that the defendant gives in the civil proceeding can't be used against the defendant in the criminal proceeding. That's existing law too. Does make clear line 19, the rules of evidence do generally apply, except that hearsay is admissible. So that's an exception. It's allowing the court in a civil forfeiture proceeding to hear evidence that might technically be hearsay in another context. Over
Here.
Guys,
Mhm.
but I feel like it's still involved in this, or it might get to the end. Because you said this is all mirrored after it's a gun is seized, firearm is.
No, that was only the petition that the person can file to have the prohibition for 5 years or whatever
Okay.
waived. And so that's a specific firearm. The rest of this is not related to
So
firearm.
my question is, so it gets seized, it's the humane officer that takes it. On the form, it's going to give the information, contact information of who now has custody of it. Is there any discussion in here of how it's determined who's eligible to take custody of the animal?
No, I'd ask your witnesses that question because I think that's also an issue. That's nothing new about this bill.
Okay.
That civil forfeiture procedure exists, and how they determine who takes custody
Yeah.
is sort of how it happens in practice. So I think I don't have any information on that, but I think your witnesses will be able to answer that question. All right, so now, all right, you go through this hearing, what happens next? Page 21, we're on that. It's the court, it's subsection E there. What if the court doesn't order forfeiture? So in other words, the court finds that the state didn't meet its burden of proof. What happens then? Well, the animal is returned to the owner upon the payment of the cost of care. Because remember, the animal still had to be held for a period of time before the court reached that decision. So costs were accumulating during that time. Person still has to pay that that accumulated expense. But, and if this is lines 5 and 6, but payment of those costs are not required if the court finds that there was no reasonable basis for the seizure. So if the court finds, hey, look, there was no basis for seizing the animals in this situation, well, then they're not going to make the person pay for it in that situation. And then as well, there's a provision in the next line that if the person doesn't make the payment, well, then whoever it was, this kind of goes to your question, well, who was holding the animal during that time? That's referred to as the custodial caretaker, line 7. That person still accumulated the cost. So it allows some reimbursement to that person from the animal welfare fund. Because remember, they've, in theory, been collecting bonds from people, but only up to, not to exceed the amount of the security, line 7 and 8. So they're not just going to have all their costs reimbursed necessarily, but if someone did post some security, well, then it makes some sense to pay back the person who incurred the cost. So that's why that's. Now, if the court does order forfeiture, in other words, the state did meet their burden, the court orders it forfeited, and then, and this is lines 13 through 16, then that security that they have paid is applied to the costs of care that were incurred by the caretaker. So in other words, you see how the idea here is to have some of these costs paid up front, so there doesn't have to be a separate action afterward. The person paid security, then you can take that security and apply it, pay it back to the custodial caretaker for whatever they incurred during that period. But if there's any extra, so let's say the person, whatever bond they submitted turned out to be more than how much it cost to care for the animal, well, that money goes back to the person who posted it. That's line 16, page 21. So there's not like a double dipping there. Go back. Should say on just election. That's not really.
Go ahead, yeah. Okay.
If you back up to that,
Yeah.
back up to where you just were though.
Yep.
The custodial caregiver is the one that's going to be on the hook for the extra expense, right? If there's not enough money there, I mean, that's not really fair to them.
That is true. Then you turn to existing law, and you're right, they'd have a gap there, right? So in that case, you look at line 19, that's under existing law, then the restitution unit could go after the person for that gap. So, but you're right, in terms of the making the custodial caretaker whole up front, they'd only be able to use that amount for, it's in.
That's just going to tie it up more in the lawyer's hands. It's just going to cost more debt, and the animal is still going to be housed. I mean, it's not going to be released.
Well, no, they would be.
It worse, right?
In this case, is assuming that, well, first of all, that's existing law. So the idea is that now there's no opportunity to get costs up front. That by having the bond, you allow them to at least get some payment back in the beginning.
But some.
Some, right.
That's not really fair.
Well, as I say, the restitution unit is the one who goes after the rest. The rest is a policy decision for you. Yeah,
You good,
I have
Ken?
a question about that. Can I ask a question that clarifies?
Yeah, as soon as I'm done grinning about policy.
Angela, go ahead.
Is it, I just want to make sure I'm understanding this. So there's a chance that the security amount would cover the care.
Mhm.
cost of care.
Mhm.
It's not a guarantee that it will meet the costs. I think the intention is that it will meet the costs and that will be developed in the rulemaking procedure, I think, and like that was referred to.
Well, the amount,
Standard.
yeah, if you look back at page 18, line 14, security has to be an amount needed to cover food and necessary veterinary care for the animal for an initial 40-day period. And then you have similar costs for a subsequent 30-day period. So again, the specifics of that will be in the rule, but that's the idea. So it could go either way. It could be that that'll be enough because the idea it's based on some hopefully estimate, well, not hopefully, definitely some estimate by people who have certainly more knowledge about how much that stuff costs than I do, or
Any of us.
I wasn't gonna say that.
I'll say.
But presumably the professionals can put an estimate together that hopefully reflects some degree of reality as to how much it'll cost. as you say, they might still end up short sometimes. Sometimes maybe they'll end up with a little more. But it'd be a good question for the witnesses as to,
I'm just gonna use a simple animal, a horse, right? That's a whole different breed of animal, pun intended, right? They're way more fussier on food. You gotta have better food, right? If the farmers or somebody hasn't got the proper cut of hay,
yeah,
they don't eat, well, maybe they will if they're starving. I don't know. But I mean, they are finicky animals, which is the only reason why I like Clydesdales. And they're finicky.
don't get me wrong. But just to kind of, because that's a very good point. And I had some discussion as I was drafting this. Presumably, this schedule is not going to be having the same amount of cost of care for, it's going to be based on the animal. And and I think you can ask your witnesses about this, particularly the witness who is going to have to develop the schedule, for example. You know.
Am I looking at her?
Yes. Hey, what's the plan? You know, and I think your answer will be, yeah, it's going to depend on the animal and all that.
So, we're gonna hold questions for you to go get through the rest of this so we can get to Stephen Brown and
Sure.
we can circle
Yeah.
back around with questions, and we do have, we'll have that.
Yeah,
opportunity
and
back up to-
Language and it's.
Yeah, so, yeah, we could go through that and then we can hear from, State Secretary Brown. So what?
So should I take a
So,
break?
yeah, no,
now?
no, go ahead and.
Okay, yeah, either way, it's fine. Though.
What, about 5-10 minutes, just to kind of
Sure,
walk
yep.
through the rest?
Yep.
And then we'll circle back with questions.
Yeah, sounds good. So let's get over to page 22 is where we are next. Then we just sort of got through that procedures of what happens if the bond or security rather. There was an appeal right to it's bottom page 22. Forfeiture order may be appealed to the Supreme Court and add some, again, trying to move these timelines on. If a notice of appeal is filed within 5 days after the order is issued and the appellant posts security, again, this goes back to Representative Arsenault's question about why did we have that security language down at the end there? Because there's also a requirement, if you're going to appeal it, you can appeal it. But again, it's making clear you have to post security for the appeal period as well. But again, same point that Representative Oliver was making, which is that there's a financial hardship exemption as well. So that applies to all of that. That's why that language is at the end. So yeah, they do have to post security, but they can get a hardship exemption for that. And then you have the timelines of and that language just repeats page 20. That's just a repeating of the exact same language about security mechanisms. It gets paid to the Animal Welfare Division and gets paid to the court rather, and they transfer to the Animal Welfare Fund. And then again, you have some timelines on the appeal, lines 13 and 14 shall be an expedited timeline. Final decision issued within 5 business days after the hearing. All right, so now we're going to can move. We've actually already looked at this already. So bottom page 23, this is the list a number of officers who are included in the crime of impeding a public officer. So it's unlawful for a person to interfere with these officers. It adds the director of welfare to that. Where a person impedes them, for example, while they're conducting an investigation, that it gets added to that crime. Over on page 24, there's some language that the time limits are not jurisdictional, may be extended for good cause shown. So again, there is a good cause ability of the court to extend these. And there's the language we looked at earlier, security may be reduced or waived on the basis of financial hardship. Now, this part we don't have to say much about, but if you start on page 24, line 5, you see no changes for the next several pages, all the way over on to page 27. Because what is all that? That's that cost of care action that was in the bill as introduced. That's this whole separate thing from this forfeiture proceeding we were just talking about. That's the one where a separate civil action can be filed by that custodial caretaker, the person who had custody of the animal during that period, or the state. And they can try and recover costs that way as well. You may decide that this isn't necessary now because of the streamlined, expedited forfeiture proceeding with the new timelines and the new mechanisms for payment of the security up front. You know, it may not be, that's a different approach. So you may still want to have this, you may not, but it's still in here for now because that's a committee decision. So that brings us all the way over to page 27, and this is in Title 20. You see, we've moved now from Title 13 to Title 20. That's the public safety title where the Division of Animal Welfare was placed last year when that statute was passed. And you'll see that link starts at the very bottom, page 27, and this adds to the list of things that the Division of Animal Welfare has authority to do. What do they have authority to do? Turn over to page 8. Actually, they're required to adopt rules. And what are the rules going to involve? That's lines 3 through 8. Representative Goslant, this kind of responds to what you were bringing up. The rules have to provide for the receipt and management of security posted in animal forfeiture proceedings and transferred to the fund by the courts, including the amount required, and to make distributions and reimbursements from the fund for the purposes authorized by, which is the statute we were just looking at. So they can make reimbursements to these organizations that, for example, were holding these animals for 3 months while the court proceeding was going on, to reimburse them for their costs. That's the idea. And now the fund itself, there's a statute also right there next in existing that you passed last year that creates the Animal Welfare Fund within the Department of Public Safety. So this has to make some tweaks to that fund to adapt to what we were just looking at. What does it do? It says the fund, what's going to be in the fund? You'll see existing law 1 and 2, revenue collected from surcharges associated with certain offenses, appropriations made by the General Assembly, and then what do you add? Subdivision 3, security posted at animal forfeiture proceedings and transferred to the fund by the court. So that stuff goes right into the fund. And then over on page 29, subsection D, Director of Animal Welfare has the authority to make distributions or reimbursements from the fund for the purposes authorized by the forfeiture statute we were just looking at. You wrote all that in.
Thank you very much. No, that was good. And I noted some of my own questions, and I know other people may have questions. So we'll have you come back after we talk to Stephen Brown, a couple questions.
Sounds great.
And I know we're going to be having you back on Tuesday of next week, and maybe have you sit in tomorrow. So Judge Zone A, we're going to schedule Zone A for tomorrow at 11.
Okay. He's not coming today?
Yeah, he ran out of time.
Right.
But for now, we'll hear from State's Attorney Brown, and then we'll take a break before we turn to some other business. Thank you for making some time available for us, Stephen. I really appreciate it.
Well, thank you for inviting me. I really appreciate the opportunity to testify about this bill. Just to be candid, I have thoroughly reviewed the bill as introduced, and I just got the second edition of the bill this morning, and I read through it while I was sitting in the courtroom. So I can't say I've fully digested it, but I think I got the gist of the changes that were made, and I appreciate the committee getting that bill to me before I testified this morning. So my name is Steve Brown. I am the state's attorney of Windham County, and I've been practicing as a prosecutor for 18 plus years. And I, fortunately or unfortunately, have handled a number of these proceedings over the course of my career. And I think the changes that are being proposed by the committee make a lot of sense and really are needed changes. I'm happy to go through kind of point by point some of the things that I've highlighted, if that's helpful for the committee.
Great. Yeah, that's very helpful. Thank you.
Okay. So if you go to section 353B3, there's language, at least in the bills introduced, and I think it remained in the latest edition, that allows a court to extend a order for a person not to possess, own, or care for any animal. I think it's a 5-year period and a 10-year period. That makes a lot of sense. The one question that I had when I was reviewing the bills introduced was, what is the enforcement mechanism? Are you expecting people to be on probation for that length of period of time? But when I read the new bill, I did really like the added language that makes it, that I think provides an enforcement mechanism that makes it a crime to possess an animal after being ordered by a court not to possess it. And that makes a lot of sense. I think we can get some good outcomes without having to put somebody on probation or some other type of sentence. Just having an order in place is great. And now there's an enforcement mechanism. So I think it's a great change. on the topic of enforcement mechanisms, if you go to 353B5, and I'm referencing the bills introduced, there's language about periodic unannounced visits. And the language that was added to the bills introduced added defendant beginning after the end of the 5-year prohibition to own, possess, or care for an animal for a period as described in subdivision 3 of this section. So it allows for visits to people's properties once they've been then allowed to possess animals. What is the enforcement mechanism? What happens when somebody says, no, you're not coming out of my property. No, you can't come and inspect my barn, whatever the location is where the animals are residing. So I think the committee should think about what type of enforcement mechanism we need to enforce that provision. In 353F, as in the bill that was introduced.
Could you hold just for 1 second? Any suggestions on that, on an enforcement mechanism? Our legislative council may have a suggestion on it. So, but if you have
let me think about that. I'm happy to think about that and email some of your committee members. I don't want to shoot off the hip.
Okay, no, that's fine.
In 353F, there was language that replaced the word telephone testimony with remote testimony. And that was omitted, I think, in the latest version of the bill. The old bill allowed telephone testimony. We obviously now have the ability to use WebEx and Zoom. And I think it would just update the statute to be in current practice. And it gives folks greater protections because you can actually see the person testifying in lieu of just hearing them testify. I don't think that's a terribly controversial change to the language of the statute. In 354A, this is not a huge change, but in 354A, there's language that requires the Secretary of Agriculture, Food and Markets shall be consulted prior to any enforcement action brought pursuant to this chapter that involves livestock and poultry. That language has been interpreted by the Vermont Supreme Court to be essentially advisory. There is no language in the statute that provides any sort of relief to a person who's had a case filed against them or other enforcement action. So in other words, it would be helpful to have language that clarifies 354A to mean it's advisory, because the Supreme Court in State versus Bona, I can give the citation to you all. It's a 3-justice opinion, 2015 Westlaw 5793234. I'll say it again, 2015 Westlaw 5793234. The opinion says clearly a failure to consult consult with the secretary does not require dismissal of a criminal or civil action. And so perhaps to have some language that says that in 354A, it would be helpful to have that clarified. So there's no question that the failure to consult isn't fatal to a criminal action or civil forfeiture action. And then it brings me to cost of care, which is obviously the hot topic that the committee is dealing with here. And first, I want to say that on the cost of care branch, we need to have language in the statute that provides some limited immunity to humane societies and other custodial caregivers who are taking in the animals. And let me explain what I mean. So animal forfeitures range from a fairly simple forfeiture of one animal, let's say a cat, all the way up to, let's say, dozens of horses or other livestock. When we are seizing a cat, that is not a particularly complicated operation. Seizing larger farm animals, horses, cows, requires a lot of planning and often requires resources that really we don't have in state law enforcement. And the humane societies and some of the care providers will come onto the site to help remove the animals from the site. And what I'm hearing from the care providers, the nonprofits, the agencies who aren't funded, who get no funding from the state, is that they are having trouble getting insured because of risk of lawsuit, helping law enforcement and being involved in these cases. So if we could have some language that provides some limited immunity from lawsuit when these agencies are being asked to help law enforcement take animals that have been abused and neglected off of a property, that'd be hugely helpful. It would also be hugely helpful to have language that extends that immunity while the caregiver is caring for the animal prior to forfeiture. So that period between the seizure and the forfeiture, I'm not suggesting that it should be all outright immunity, but it should perhaps be an immunity that requires, if a lawsuit is brought, it needs to be some sort of gross misconduct on the part of the caregiver, because we don't want these caregivers are already saddled with very, in some cases, very expensive care of animals. And I just heard some of that discussion. I think when I logged in, we don't want these agencies to also then have to be faced with litigation because they're being called upon by us to help them care for the animals. So that's really my first ask, and that's really one of my most important asks that I'm here to ask the committee to consider. A couple other items I would like to highlight that would allow caregivers and humane societies under the statute to initiate their own enforcement action to collect a judgment. So let's pretend we have a case where we have a judgment against a person. The court has found that the animals should be forfeited. The court then held a cost of care hearing and has determined, for example, that $50,000 of care is owed to the caregiver. The statute currently allows the restitution judgment order, a restitution unit, to collect the judgment. I think that the caregiver should also be permitted to file independent collection proceeding to collect on those judgment orders as well. It just gives them a little bit more leeway and authority to go after the collection end of the case.
Can you take a question on that particular issue? Is that
yes.
Tom? Tom, do you have a question on that?
Yeah, it's similar. I've got two little questions. My first one would be, has there ever been any necessity in one of your cases in your experience where there needed to be forensic examinations or examinations for purpose of evidence that might cost money by a vet?
Yeah, I think I understand the question. So have we ever had to use resources to get an animal examined so that we could use that examination in a court proceeding? Is that?
Yeah.
Yeah. So the animals, in my experience, are always examined by veterinarians, and the cost is often incurred by the caregivers. The veterinarians that I've worked with over the years, for the most part, have always been very willing to come and testify and to do their part in these cases. I've never had pushback from veterinarians to testify when called upon. Yeah, the examination is a part of every case because we need that evidence, especially if there's medical neglect being alleged.
I have a part two to that, and it kind of has to do with how I used to deal with this stuff involving humans, people. And that would be, until ownership is transferred of that animal to say, a humane society or whoever, I personally believe that the person who's getting the bill is the person responsible for the animal. Like,
Yes, fundamentally, that's what happens, but that's not. It takes
Right.
there's some steps to get to that point, and currently under the law, we have to have the animal has to have been forfeited, and then there needs to be a cost of care hearing where a court has to determine that the care has been reasonable and that the costs incurred were a function of the seizure. And that hasn't been traditionally a huge obstacle, but it takes a lot of time. And every day that is a day that the horse or cat or dog or animals be in the care of a caregiver and hasn't been forfeited is a day that they're incurring additional expense. So even once forfeiture happens, there's an appeal period, and the current statute allows the animal to be then transferred pending appeal. So that's usually not a roadblock, but the longer it takes to get to the forfeiture decision, the longer and the larger the bills are for the cost of the animal. And some of the bills I've seen have been over $250,000. We're not talking, we're not talking small amounts of money.
thank you.
Angela, yeah, another question for you as well.
Yeah, thank you so much for being here. And I'm curious, your point about independent, like the ability to initiate an independent collection proceeding. I guess the implication is that right now, folks are barred from doing that, or they're just that pathway doesn't exist. Is that true?
So it's not clear to me that pathway exists. I'm not sure they're barred from that, but I think there's potentially an argument that perhaps they could be barred from that. I've never explored it. I'm not aware of any court decisions one way or the other on that issue. But in the instance where there's a judgment that's a substantial amount of money, upwards of over $100,000, it would it would be a nice option for caregivers to be able to, and humane societies to be able to have that option to have their own counsel go out and try to collect through legal means, through the court system, to collect on that judgment and perhaps take that judgment outside the state of Vermont. And I don't know how far the restitution unit will go to collect, but sometimes private counsel has additional resources that maybe the state doesn't have to go out and assist in collecting those debts.
And is your concern for your, understandable concern for that the need for that pathway alleviated at all with the new proposal? And I know you just received it, but with this setting up a system, through which the security is posted or the animal is forfeited, and potentially caregivers are receiving at least some of that money up front. Does that make it? Do you see that as an improvement?
Yeah, I think potentially that could alleviate some of the issues that we're currently seeing under the statute. Because right now, as the bill currently reads, in order for somebody to initiate a challenge to the forfeiture, they need to, if I read the bill correctly, they need to post that bond at the beginning of the litigation. So potentially that could help. Yes. And while we're on that subject, may I also highlight a procedural question that I had. When animals are seized from a owner, would the state be serving some sort of formal official notice that a forfeiture proceeding has been initiated? And should that notice provide the procedural steps that an owner should take in order to challenge the forfeiture. In other words, I didn't see it in the statute. I didn't see that the state had any sort of duty to provide the owners with any sort of information at the beginning. And I would recommend that the statute lay out what exactly we would need to be providing owners who've had animals seized and what steps they need or need not take in order to move forward. Does that make sense?
Yeah, we talked a little bit about this before you got on, as far as a notice, making sure there's a notice to the owner, either at the time of seizure, there's going to have to be some sort of service of notice to the individual, but it still is a little bit different, and it puts the onus, and that will be part of the description of whatever is provided owner, that they actually have to request the hearing, and within 14 days, it's going to be that they would have to request a hearing. And then within 30 days, they would have that hearing. So there puts some onus on the owner to take that step. And if they don't, then the animal would be forfeited. So that's the approach that we've taken. But we are going to clarify that in the next version of this.
Yeah, it'd be good to clarify what the notice should look like, what information should be in it. And
do you have the, sorry.
Yeah, he
do you
does.
have you have the new, so on page 17 of the new draft 1.1, lines, starting on page 17, line 12 and going over to page 18, lines 1 through 7. I wonder if that's what you're talking about. So it's, saying that notice shall be given at the time of seizure, and then it says what the notice shall include.
Okay.
So if you can take a look at that
page
when you have a minute and let us know if we're missing anything.
Okay. I will do that. My computer is not particularly happy with me right now, so
you can certainly get back to can get back to us on that particular question.
Yeah, and just so you know, we did talk about adding as a required element of that notice, information about steps for proving financial hardship.
Okay. That's great.
Or the existence of that option, I should say.
That was one of the other questions I had is what happens when somebody doesn't have the financial means to post a bond? Okay. And it looked like the current draft has kind of meshed what I was calling the bond hearing and the forfeiture hearing into one proceeding. The initial draft kind of had you could have dual cases pending. You could have the bond case pending and the forfeiture, but it looks like they've been meshed together. Is that a fair assessment? Okay.
Yes.
Okay. I will, of course, take a deeper dive into the new draft, and I'm happy to share those thoughts with the committee. I'm happy to answer more questions. I'm happy to do whatever you all would like me to do.
Any other questions? Yeah, we definitely appreciate if you have additional comments to submit those. This is a bill that will be having hopefully only one more version. Hopefully this is the penultimate version, but we'll see what happens with that. So yeah, anything that you could provide by the beginning of next week would be appreciated. But Angela has a question as well.
I have a question that I think is for you that I didn't ask our legislative council. I again, this is new language in the most recent draft. So, let me know if you want to think about it a little bit. On page 20, lines 19 and 20, we say the rules of evidence shall apply in the forfeiture hearing, except that hearsay shall be admissible. And I just wondered if you have thoughts on why, or if it's important to allow hearsay in these cases.
Yeah, the committee may want to clarify what type of hearsay. It may want to use the word reliable hearsay. And there's a very robust body of case law that we currently have that interprets what what reliable hearsay means in the statute. Reliable hearsay, that word is, or that phrase is used throughout the statutes and the rules. Reliable hearsay would allow, for example, a affidavit from a veterinarian or an affidavit from a law enforcement officer with firsthand accounts. And obviously, an affidavit from a law enforcement officer recounting what somebody else told them may get you out of the realm of reliable hearsay. But reliable hearsay it's been litigated. It has a meaning to lawyers and judges, and I think is probably a safe phrase to use for this type of proceeding.
Okay, thank you.
I think that, you know, currently the statute allows the use of affidavits to prove up the state's case under forfeiture if the affiant, the veterinarian or law enforcement officer, is available to testify currently by telephone, although we use WebEx. So, you know, you may want to make sure there's some safeguards in there to make sure that any hearsay, any reliable hearsay that is used, perhaps the affiant is available in some mechanism to testify. If it's, you know, remote, that really takes the burden off of a witness having to travel a long distance to get to a court for a hearing. Because we have veterinarians that are all over the place who have treated animals that we've seized, and to ask a veterinarian to take an entire day to come testify for 20 minutes is really difficult. But when they can hop on a WebEx and testify for 20 minutes, it's been huge. It's been really helpful, and has definitely allowed us to move cases forward.
Great, thank you.
All right, thank you so much for your time. I really appreciate it. I'm glad that we were able to finally fit you in keep on working on that backlog. We appreciate your work.
I apparently I bored Representative Goodnow enough, so he left the committee room. So
Yeah, definitely give him some grief for that. Yeah.
All right, thank you, everybody.
Thank you. So we're gonna take a break till quarter after, and then we're gonna look actually at. We have to do a drive-by of 540, which is a bill that's in corrections, and Hillary. We're gonna have Hillary do a walkthrough. We're all very excited about that, and then we will hopefully still have time then for Jeannie and